All right, all right. What is going on, Bree Hive? Welcome back to yet another live stream on a lovely Tuesday evening, or I guess night for a lot of people. What is going on? Let me know how everyone is doing. How was your weekend? Are you ready for the Super Bowl? And are you ready for the cases that we have to cover today? We are going back in time to some cases that we have already covered. We got MrBeast filing anti-Slapp motions. We got Lizzo's filing motions to dismiss, which was apparently denied. We're going to go through it and the reasoning given for both of the cases. Now, this today is going to be a complete live reaction because it has technical difficulties. So I know a little bit about it, but please bear with me if I'm skipping through or not skipping, but messing up through the documents because this is a live reaction. Let me know if you guys are here watching live. If you're watching on the replay, make sure to comment below under the live stream. Let me know where you're watching from. And I'm already late, so let's jump right into it. And we always have to say hi to our good friend, Bossy the Beat. So all right, we are ready nonetheless. And then I guess I can give like a little brief intro. If you don't know about MrBeast, he basically sued a company that he contracted with to do a burger joint or a ghost kitchen burger joint. And he sued them saying that they basically weren't upholding their end of the bargain. They're providing bad food for people. He's getting bad reputation for it. And he wants to be able to basically get out of the contract. They then countersued him back, basically saying he did not uphold his end of the deal. He did not make the post that he was required to post to, advertise the business and everything. And they countersued him. MrBeast is now responding to them with an anti-Slapp motion, basically asking for them, or part of their things is that he was saying bad things about them online. So he is now filing an anti-Slapp motion, basically saying I can say bad things about them, basically because they were giving me a bad reputation and I have the right to warn the public that I'm in this contract, but they are not abiding by the rules. And then we have Lizzo, who was sued 2 times, but the case that we're talking about today is the case where she was sued by the dancers on her team. 3 of her dancers sued her, basically alleging SH, racism, disability discrimination. There was interference with the contract or interference with work. They said they could not go out and work because Lizzo basically did not allow them to. So Lizzo filed a motion to dismiss. She basically denied all of the allegations and then said, hey, the court should dismiss this because they failed to state a claim. Well, a portion of it got dismissed, and we're going to look into the motion and the ruling on it in just a moment. A portion of it got dismissed, and a portion of it is still surviving. People are very much so reporting and stating that, the SH and the SA claims did not get dismissed. The racial discrimination did not get dismissed. The disability did not get dismissed. So we're going to go through it and see what was the reasoning. I believe we have the ruling. Yes, we have the ruling, so we'll go over the reasoning with it. And welcome to everyone that is watching over on TikTok, y'all. I got the TikTok live going up. We got the YouTube live going up. If you are here live, make sure you do hit the like button. It does help us out in the algorithm. I am newer to live streaming on this TikTok channel, so much appreciated if you guys can hit the like button. And of course, OGs on the YouTube channel, make sure you hit the like button to help us out in the algorithm so we can get some more friends in here watching live. While we are at it, let's go ahead and check where our likes are at so that we can go ahead and set our like goal for the stream. We are at 8 likes with 10 people watching live. So if you have not hit the like button, please do. And we're going to make our goal 30 likes for the live stream over on YouTube. We got 0 likes over on TikTok. So if y'all are watching live over on TikTok, make sure you do hit the like button. It does help us out and get more friends over to the channel. Let me go ahead and say what's up to the people that are here live on YouTube. And I guess I'll check out TikTok to see who's there live there. Let's go. And thank y'all all for waiting. I know I was a little bit late, but we are here nonetheless, and we're going to have a good time talking about all of this stuff. So We have Tanya D saying, I'm just being nosy and stopping by to see who hit the like button early. See y'all in a couple of hours. Tanya D, a member and moderator of the channel. Welcome back to the live stream. Thank you for engaging with the content, hitting the like button. And we had a couple likes before the live stream started. So shout out to the Bree Hive on that. We have Spirit of the Trees, another member of the channel, saying hello, 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 and welcome into the live stream. Nice to see you again tonight. We got Spirit of the Trees also hitting the like button. Definitely appreciate it. Cardoba82, welcome back to the live stream. Nice to see you tonight. Saying great evening to Tanya D and Spirit of the Trees. How wonderful to see you. And it is always wonderful to see the Bree Hive. Cardoba82 says hello to our queen and the Bree Hive. Hello to you as well. We're happy to have you in tonight. Let me know if you guys have heard about these. I mean, I know if you are OG YouTubers, YouTube subscribers for me, you have heard about these cases. We've covered these cases before, but let me know basically if you guys heard the update. What do you think about the update so far? And we're going to get right into it. I'll let y'all know I was running a bit late. I appreciate y'all for holding it down and waiting for me to come on out. Saying don't fret, we'll wait. Appreciate it for sure. Tanya D says, I'm doing some work on my computer anyway. Well, thank you guys for just waiting. I know I was like feeling bad because like, oh, I'm going to be on time today. And then I'll tell y'all the truth. I was watching First 48 and it was getting so good. And then I looked up and it was like, oh, you are about to be late to your live stream. But I also hadn't reviewed the document. So I was waiting to figure that out. So yeah, I'm just a mess right now today, but that's okay. We're going to get it together. We are going to get it together. Tanya D says, shout out to the replay crew. Make sure you hit the like button and leave a comment. Let us know you stopped by. Yes. And we had quite a few comments on the last live stream. So shout out to everyone that watched the replay on the live stream. We were talking about the Jeanette Braun and Lauren the Mortician lawsuit. We had a special guest come on to the live stream to tell us his experience. If you missed it, you got to go back and watch it to see what he had to say and who it was. We had a special guest. I believe he came in around 30 minutes to an hour into the live stream. So I have not put timestamps on videos in a while, and I need to get back to doing it. So please bear with me on that, y'all. And yes, shout out to the replay crew and also the people here watching live. Just Me MD, another member of the channel. Hello, welcome back into the live stream. Nice to see you today. Saying hi, Bree Hive family. Love from East Texas. Hello and welcome back into the live stream. Nice to see you tonight. All right, Tanya D is down in Texas. What's going on in Texas? Just Me MD says, greetings, Beehive, sending love from East Texas. My comment section is acting up. It is all good. We are happy to have you here tonight. We have Z Seltzer, another member of the channel. Hello and welcome back into the live stream. Nice to see you tonight. Saying hi to the Bree Hive, giving us a waving pink hand. Hello to you and welcome in. Henry Smith, welcome back. Saying I didn't get notified. I'm sorry. YouTube does me wrong a lot of times, but we are happy that you made it here live and hopefully you enjoy the live stream. Nice to have you back tonight. Let's see. I don't know what happened. Oh, the Bree Hive. Yeah. I was like, the Beehive. I'm like, am I confusing people? I hope not. Okay. Henry Smith says, glad you started late because I didn't get notified. I don't know what's up with YouTube. Sometimes they will notify people, sometimes they won't. But I don't know how to fix that. But we are happy that you made it here. Doodle Noise, another member of the channel, saying hi, happy to see you all this evening. Hello and welcome in. Nice to see you as well. Henry Smith saying that's a legit excuse. Watching for First 48. It just distracted me so good. And the sad part about it is that I watched like 2 episodes before that one. So it's like I should have been able to leave, but it had me hooked. It had me hooked so much. Okay, saying hi, good to see you. The Young Legend says, life teaches us to make good use of time, while time teaches us the values of life. So before a flower becomes beautiful, it must first go through dirt. Oh, that's lovely. I like that. I was going through dirt and watching TV instead of getting ready for my live stream, but I appreciate it. Nice to see you back in the live stream, the young legend. All right, let's see everybody saying hi to each other. Cardoba82 says, no problem. I actually get my notification during the live stream. You're already here, and it's like, go watch the Beehive. Y'all, I was super proud of myself. I don't know if I did something right or if just no one's talking about this case, but I actually ranked on Google this live stream for MrBeast and Anti-Slapp. And it could just be the language that I used in the title, but I was like first to pop up on Google, on the Google search engine, not on YouTube or anything like that, but on Google. I typed it in on Google and I was the first one to pop up. And I was like, you have got to be kidding me. I am ranking on search for Google. Like, no way. Maybe no one's talking about it, but I was still proud of myself. So there's that. Spirit of the Tree says, I do love that kind of stuff. First 48, I know. It's addicting and it's so bad. Like, it makes me so upset, but it's so interesting the way they just set the show up and like the process that they follow. They definitely have a good format. I need to get like them so I can get a good format too. But like the cases are so sad, and it's always something like $40 or this person said something bad about me or whatever it is. It makes absolutely no sense. It makes me so mad, but it's still so interesting that I feel like I have to watch it. So, yeah, I should stop watching it, but it's a really good show, although sad, although very, very sad. Small says, what up, Bree Hive? Hope everyone is well. Hey, Bree, how are you today? Hello, and welcome back into the live stream, Small/Hello Swanky/ I sent you a message back on TikTok, so I'm waiting for a response on that, but welcome into the live stream. Another member and moderator of the channel. Welcome back. Everyone saying hello. Henry Smith says popping up on Google search like that is definitely worthy AF. Worthy AF. Girl, get it together. Worthy of a trophy. Thank you very much. I was super excited. I was like, no freaking way is the Beehive popping up first on Google search. But it may be because I'm logged into my account. So if y'all have time to search MrBeast Anti-Slapp, let me know if it pops up first on yours. So it could just be because it's my phone. But Just Me MD says the Lizzo case is crazy. I remember watching Lizzo's Watch Out for the Big Girls in 2022. Reality, one season, it was interesting. So now I look back and can see a few moments that require a side eye. And I feel like that happens with like all of those kind of shows. Like there's a lot of backlash coming on to Tyra Banks now from that show. But I used to watch that show as a little kid and I didn't really see a problem with it. But now that more things are coming out about it, it was clearly a problem, right? So I can only imagine. I never watched Watch Out for the Big Girls, but I could only imagine what kind of stuff they were going through too. Cardoba 82 says, is it also first hit in Microsoft Bing searching? Oh, well, yay! So it was more than just me. It was more than just my search channel. That's good. Thank you for searching on Bing for me. Small says, catching up on what I missed. Super Bowl. You mean the 5th annual Janet Jackson Appreciation Day? Looking forward to it. What are we doing on Super Bowl? I have no idea what I'm doing for the Super Bowl, but we'll figure it out. Janet Jackson Appreciation Day. Let me see here. Give me Locker says, oh, you're too kind. Okay, let's see. Casta Sass, another member of the channel. Welcome back into the live stream. Nice to see you again tonight. Again, thank you for the gifted memberships that you gave out the other day. Definitely appreciate that. Tiny D says, Swanky Smalls is in the building. I just like that name. Swanky Smalls. Henry Smith says, your video appears above Emily D. Baker's video on MrBeast. Oh, snap. Don't toot my horn on that. Emily D. Baker is like the lawyer goat of YouTube, okay? As far as like the live streaming coverage, because I know there's some other YouTubers, although I still think Emily D. Baker is a little bit better than those popular YouTube lawyers. She's like the goat to the lawyer live streamers. In my opinion, that's my opinion. Don't come after me, other law tubers. We're all friends. We are all friends, I promise. Let's see. Okay, y'all are chatting it up. I definitely appreciate all of the interaction, but I have to jump into the cases. Today was actually going to be a short live stream where I only covered articles, but Kimmy, our paralegal consultant, moderator, something else. I feel like there's something else, but also a member of the channel, she came in clutch and found the documents for us. So shout out to Kimmy if y'all haven't already shouted out to her or thanked her for tonight. I was just gonna give y'all articles because I am exhausted, okay? Super exhausted, but nonetheless, shout out to Kimmy. We're gonna go ahead and jump into, let's cover Lizzo first because she has less documentation, and then we'll go ahead and jump into MrBeast and his anti-slap. Y'all know I still, as many anti-slaps as I have covered on this channel, I still do not all the way understand anti-slap, and I think that's kind of embarrassing. So one day I need to go ahead, sit down, and really look through anti-slap and try to understand it a little better. I remember looking at it on this live stream, but since it doesn't come up in like my regular practice, I don't really think about it when I'm not talking about it here on YouTube. So we'll relearn anti-slap when we get to MrBeast. But for now, we're going to go ahead and jump into Lizzo and all the crazy things going on there. So let's, Bossy B, bring it in. All right, let's do this. So Bree, share the screen. Let's go. Boom, there we are. Let's make it bigger, but not too big because it's all about my face. And this is MrBeast, so I don't have it together, y'all. All right, jumping in. Shout out to Kimmy for the highlights and I'm gonna try to remember the highlight code for us. The codes, she made a little color key for me, so I'm gonna try to remember. All right, so this is the case with Ariana Davis, with Crystal Williams and Noel Rodriguez suing Lizzo and all of the people along with her, her LLC or her incorporation, or her corporation, and then Shirlene Quigley and whoever else they can find in the future. This is a tentative order granting in part and denying in part Lizzo's special motion to strike portions of plaintiff's complaint. Which, see what live reactions do to you? I thought that this was a complete motion to dismiss, but I guess it was just a special motion to strike portions of the complaint. So let's go ahead and remind ourselves of the background that's going on. Plaintiff Ariana Davis, Crystal Williams, Noel Rodriguez filed this employment discrimination action against Big Girl Big Touring Inc., Melissa Jefferson, aka Lizzo, and Shirlene Quigley, and they're collectively called defendants. According to the operative complaint, plaintiffs are professional dancers who worked with Lizzo. Plaintiffs allege that in March 2021, Davis and Williams met Lizzo as contestants on her reality television show called Watch Out for the Big Girls. And so actually, I'm not going to read through all of this reminder of what happened, because there's a lot of information and we got a lot of stuff to get through. Let's see. They basically accused them of SH by making them go to strip clubs, male strip clubs, accused them of disability discrimination because I think she was like trying to use her phone and they told her that she couldn't. Something happened and then she lost her vision, wasn't too clear, or something happened with the disability thing that is not all the way clear to me. And then there was religion discrimination because Quigley allegedly continuously talked about religion and one of the girls' virginity. Don't know why she wanted to keep up bringing up her virginity and telling her basically to stay celibate until marriage and not give up her virginity. So there's some religion discrimination going on there, or religious harassment going on there. And then they also complained that they could not work for others, so they wanted Lizzo to pay them basically more money, or at least, pay them to hold them during the weeks where they were not touring once they finally went on tour. And then they also accused another, I believe it was also Quigley, of basically deep throating, I don't know if that's the best wording to use on the internet, a banana. She kept doing that with a banana. So let's go ahead and jump into the meat and potatoes of why we are here today. I think I covered everything with what they're alleging. in a very short version versus these 2 to 3 pages that they wrote. So let me know if you guys caught everything on that one. So we have evidentiary issues. The defendant submitted 20 declarations with their moving papers. That was followed by plaintiff's evidentiary objections to each of those declarations. So they filed declarations of basically like third parties, and I have not read all of the declarations. I just haven't read them, okay? But basically, the plaintiffs, the dancers, were objecting to the declarations. Basically, they could use it for any reason. It could be because of hearsay. It could be for lack of personal knowledge. I don't know what all of the objections were because I don't have time to read all of that. But either way, the dancers objected to those affidavits being admitted into evidence for consideration of this actual complaint or of this actual motion to dismiss. And in the reply, defendants responded to each of the objections to their declaration and lodged their own objections. Remember when we went through the answer and she basically just threw the kitchen sink at them with defenses? It was like 33 defenses, affirmative defenses in her actual response to the case. I don't know. That just reminded me of that and it tickled me. Y'all, we got 101 likes on TikTok. So shout out to TikTok. With TikTok, you can like it multiple times. And it looks like someone came by and hit the like button a couple times for us. So shout out to them over there. Let's go ahead and jump back into it. As defendants are likely aware, the number of declarations submitted here was unnecessary. The court is not having fun. The court said you submitted way too many declarations. Okay. One declaration by a person with personal knowledge detailing the relevant situation is sufficient on a motion where the standard for summary judgment apply. The court observes that defendant emphasized the fact that they submitted 20 declarations in reply, but this is not a numbers game. So basically, the court is admonishing, but not admonishing for them basically overflowing the court docket. Why are you submitting, the court is saying, why are you submitting 20 affidavits when one affidavit would have been sufficient? So they're low-key like admonishing Lizzo and the defendant. So that's kind of funny. Okay, let me get through this. I'm acting like I got all night. Okay, let's see here. The court observes that defendants emphasize, 20 like they're winning something, right? Okay. The court can make an educated guess as to why so many declarations were filed. The court would ask that such not recur unless there is some kind of legal justification for it. No more need be said on the point at present. They said, don't do it again. Don't submit all them goddamn declarations in my courtroom. Equally troubling is defendant's approach resulted in an avalanche of evidentiary objections that, again, the court would have had to go through, right? The court has reviewed the objections. The vast majority are at least partly made on the basis of relevance. The court disfavors such objections. Objecting on relevance is bad. Objecting on relevance is bad in any case that you have, whether it be family law like I practice or anything else, because the court can determine whether something is relevant or not. Especially they objected to all 20 declarations, which they had to have some type of relevant information in it. Y'all are doing too much is basically what the court is telling them here. So let's see here. Don't keep objecting on relevance. It's not a good objection. By definition, if the proffered evidence is irrelevant, then it can have no part in the court's analysis, objections or not. On the other hand, if the evidence is relevant, then the objection is not well taken because you're basically just boilerplate objecting at that point. The party should refrain from making relevance or 352 objections. 352 objections. The party should refrain from relevant objections or 352 relevant objections and motions in the future absent some good reason to do so. The court is not happy. Shout out to Kimmy for pulling this document because I was just going to read the articles, and the articles do this no justice. No justice at all. Okay. Aside from that, the court will not rule on the individual objections. Many of the objections are to immaterial evidence. Plaintiffs are reminded for our Supreme Court statement that only I know I was not going to be able to say this. Only meritorious objections should be raised, and even then, only to evidence that makes a difference. Here, the objections do not meet the standard and constitute the blunderbuss objections to virtually every item of evidence that the Reed Court explicitly warned against. You can't make the same objection to every single thing. I wish they would tell that to some of the people I practice against. Going through that right now. Any meritorious objections are lost within the pages of unmeritorious objections. So you should have made objections to things that were actually necessary than all of these random objections that you made, is basically what the court is saying. This is not to say that the court has accepted defendants' evidence carte blanche. Many of the declarations contain hearsay and statements without foundation or personal knowledge. The court has not considered statements that suffer from these defects. So they basically acknowledged any statements that an objection could have succeeded on based on lack of foundation, lack of personal knowledge, and and that it was hearsay. So of course, we know that hearsay, I don't know if of course, but hearsay is basically a statement offered to prove the truth or falsity of the statement being made. You cannot do that unless it is like the defendant saying it and you're using it against the defendant. Versus if Bobby Joe from the dance team said, I heard Lizzo say these things, then they cannot use that into court unless Lizzo, or unless the person who they heard say Lizzo said that thing is there to testify on that behalf. Then we have lack of foundation. They basically didn't establish how they knew this. It's basically like them just coming out and saying, Quigley is not religious, or Quigley is religious, or whatever it is, but they have no foundation or how they even know that. And then of course, lack of personal knowledge. You weren't even there, so how the heck are you going to testify to this? The affidavit is just people testifying, but in writing so that the court can review it. So the court explained that. Let's see here. Where was I at? Defendants also filed evidentiary objections in reply. The court declines to rule on defendants' numerous objections to immaterial evidence for the same reason. With that said, where the material portions of the declaration suffer from issues on personal knowledge, the gap is easily filled because the plaintiff with personal knowledge also submitted a declaration detailing their viewpoint. So wouldn't be hearsay because the person with the knowledge is coming forward and basically confirming the things that the person without actual knowledge said, if that makes sense. The declarations are not conclusory as they provide sufficient explanation for why plaintiffs felt the way they did or perceived certain actions as pretextual. For the same reasons, the declarations are not speculative. Most of the hearsay objections lack merit, as some statements are by people authorized by the party to make statements. Those that have merit are rarely to material evidence. I don't know what that means. That leaves the objection to the jurat. I guess I'm assuming jurat. I don't know what that means, y'all. I'm not gonna lie to y'all. Plaintiffs do not specify where they executed the declaration and only end with, I declare under penalty of perjury for the state of California that the above is true and correct. Defendants argues this violates the civil procedure section. The place of execution is missing, but the court believes there is substantial compliance. I agree with that. That sounds like the line that we use. It might be missing some language from it, but it's not something that is going to be material to them signing under penalty of perjury. In short, the court is not going to throw out the case on a curable jurat to the extent it is defective and it likely is not defective anyway, because the court is basically saying that they met it substantially. There's legal standards for the case. This is basically, let's see here. California legislature has authorized that a special motion to strike may be filed in the lawsuit that seeks to chill the valid exercise of constitutional rights of freedom of speech and petition for redress and grievances. I believe this is also an anti-Slapp motion, which I completely forgot about. So let me know if y'all realize this was also an anti-Slapp motion, because apparently I missed it. Okay, according to section 425.16, is based on a two-step process for determining whether a SMS should be granted special motion to strike. First, the court decides whether the defendant has made a threshold showing that the challenge claims or causes of action arise from protected activity. Remember, we read we did go over the motion, didn't we? I cover so much stuff on the channel. I forget what I believe we did go over the motion to strike. That's when she was saying that she had protected speech to pick who's the dancer and how they dance and where they change, and it's a part of the standard for dancers is just to change backstage, and there's no real issue behind it. So yes, this one is anti-Slapp. That's what I forgot. I completely forgot. So we are back on the right page. But so this is basically anti-Slapp. I should be able to do these things because it's basically protected under the First Amendment, Constitution, and also freedom of speech for some of the stuff that she said, I believe. So I should have probably reviewed that before I got on here. If the defendant makes that threshold showing, the burden shifts to plaintiff. Oh, sorry, y'all. The burden shifts to plaintiffs to establish a likelihood of prevailing on the complaint. The burden on plaintiff, like the burden imposed to defeat the summary judgment motion, the plaintiff must submit admissible evidence showing that it can prevail. The court does not weigh the evidence or determine issues of credibility, nor does the court resolve any factual dispute. Rather, in a motion for summary judgment, if the plaintiff can put forward evidence that, if true, would establish its claim in light of all reasonable favorable inferences, the special motion to strike will be denied. So apparently they met this burden on some of the issues. Rather, all the court must determine is whether there is some probability, meaning that plaintiff has put forth enough evidence such that it is believed is sufficient to allow a reasonable jury to find in plaintiff's favor. So let's see the analysis. Okay. Acts in furtherance of defendant's right of the petition or free speech, the prong one. To invoke this section, defendant need only demonstrate that a suit arises from the defendant's exercise of free speech or petition rights. In the anti-Slapp context, the critical point is whether the plaintiff's cause of action itself was based on an act in furtherance of the defendant's right of petition or free speech. We wanted to hear about this, so let's see what the court actually says. Defendants argue that the acts complained of in the complaint all consist of activity that is part of the creative process and therefore protected. So I get to take you to a strip club. I get to comment on, your virginity. I get to put a banana deep down I'm not saying that online. I'm not going to say that online. But they get to put a banana in their throat and pretend like it is a male body part. That is all protected speech. I'm going to think not. And I think that's why the sexual harassment or the SH was upheld in this case. So let's get into it. Defendants argue that the acts, that they were protected speech. The subsection protects any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. What constitutes a statement made in connection with an issue of public interest is the same under the subdivisions. There is another two-step test to determine the issue. First, we ask what public issue or issue of public interest the speech in question implicates. This should get interesting. I don't know how they're going to be able to prove that some of the activity that was going on with Lizzo would be considered protected speech. In what way is treating a banana like a male reproductive organ freedom of speech? Is it team bonding? Maybe. That's so bad. Let me me get into the case because we're about to be here playing all night, okay? Okay. And then second, we ask what functional relationship exists between the speech and the public conversation about some matter of public interest. Defendants insist that the television show and Lizzo's own fame are within a public interest. You can't just do a blanket claim like this. I would love to see how the court rules on this. I believe there was already a case where they ruled against this notion. So here, the Court of Appeals properly identified three non-exclusive and sometimes overlapping categories of statements within the ambit of subdivision E4. The first is when the statement or conduct concerns a person or entity in the public eye. So, I mean, Lizzo is in the public eye. Second is when it involves conduct that could directly affect a large number of people beyond the direct participants. Okay. And third is when it involves a topic of widespread public interest. Okay, she might win on that one. I thought there was something against the whole blanket statement thing. Defendants point out that Lizzo's concerts, television shows, and public statements on certain issues are in the public interest due to her status as a major celebrity. The court agrees. So I was wrong. I was wrong on the internet, y'all. Don't cancel me. Plaintiffs argue in opposition that Lizzo's status as a celebrity alone is insufficient because there can be no claimed public interest in cast meetings and outings, prayer groups, or things like that. Stripped of context, plaintiff is correct. So, yes, it could be. The thing is that it revolves around public interest, but maybe her forcing you to pray in prayer circles before your dance meeting may still be a violation, or her forcing you to go to a strip club may still be a violation, but she falls into that public interest realm. So we got to see how the court rules on that second part of the test. So at this point, Lizzo is winning the first part of the test. She falls within the public interest because she is a celebrity. Let's see here. Plaintiffs argue in opposition. But when the issue becomes Lizzo's cast meetings and outings, prayer groups, and things like that, while on tour, the analysis is different. If it is Lizzo's celebrity that elevates these perhaps mundane issues into those average citizens want to know more about. Let's see here. The court believes that the first step of the film on analysis is satisfied. She is a celebrity. I thought that, I get it. Since she's on tour, then it makes it then it becomes more of an issue versus if she was just a celebrity eating dinner, then it may not satisfy this prong. I see what the court was saying there. Okay. As to the second film on step, defendants assert that the acts that further the creative process are protected. Courts have held that acts that advance or assist the creation and performance of artistic works are acts in furtherance of the right of free speech for anti-Slapp purposes. This is true, but defendants' argument overstates the connection between certain acts and the creative process, like the banana team bonding. Yep, tiny team bonding. That's what we'll call it. Call it team bonding. While many of these acts occur during a tour and in preparation for it, that alone does not satisfy the second film on step. The second step requires a consideration whether a defendant through public or private speech or conduct participated in or furthered the discourse that makes an issue one of public interest. What a court scrutinizing the nature of speech in the anti-Slapp context must focus on is the speech at hand, rather than the prospect that such speech may conceivably have indirect consequences for an issue of public concern. Accordingly, the analysis needs to be more granular. Thus, while the court understands the argument and agrees that the fact that this case involves a well-known mega celebrity brings a lot of conduct into the constitutionally protected ambit that would not otherwise be there, it is not without bound. The court must look closely at the actual things alleged and the evidence presented to determine if it is fairly within or outside of the constitutionally protected speech of public interest, which I'm sure the court is going to find that some of it is not. Defendants contend that all of the allegations supporting all of the causes of actions concern the creative process. I don't think so. I don't think you're going to be able to get away with that, Lizzo. The nude photo shoot, they assert, took place during filming of Watch Out for the Big Girls to choose dancers for the tour, and providing feedback on dancers or terminating employees who were not up to par is encompassed within the process. The court agrees. The creation of a television show is an exercise of free speech, correct? Hiring and firing dancers for a television show and eventual tour is also a part of the creative process. Thus, the nude photo shoot is protected. So that was one of the things. I'm just like, the banana is not going to fly. The banana is not going to fly. Some of them are not. Okay. The court believes this protection extends to providing feedback to dancers during various meetings as well as the re-audition process. All of this is part of creating the performance that the artist envisions in her head. The private meeting with Davis is protected too. As alleged and as the evidence supports, the meeting centered around Davis's personality changes during the tour. And remember, I believe she was saying that she had like some type of depression or something like that. And they had a meeting with her basically to say, hey, you're not performing up to par. So I see why the court decided that. Davis alleges that was fiend concern and was veiled reference to her weight gain, because remember, she was going through a lot and she gained some weight. Maybe so, because maybe they were talking about you gaining some weight, girl, but the allegations still indicate this meeting was related to Davis's job performance on the tour. Lizzo attests that she worried that the tour was too much for Davis and wanted to check in with her. This bears a relationship with Davis's health on tour, and according even to plaintiffs, Davis' job safety, because she's having some problems, she's having mental illness that can affect her performance. She can fall off the stage, maybe. I don't know. We don't know. The soft hold and comments within the context of retainer negotiations are also protected. Remember, they complained that they were not able to take extra jobs because Lizzo did not want them dancing with other people. The negotiation for a soft hold retainer are protected because they concern staffing for a tour. Joshy's comments during negotiations are also protected because they communicate lax job performance during concerts and note that this is grounds for termination. Production of a show and personnel decisions related to that are protected. The same applies to the comments calling Black members of the dance team lazy, unprofessional, or snarky. Oh gosh. I don't really know how to feel about the way that was phrased. I really don't know how to feel about the way that was phrased. I get that they can critique the way that they're dancing. I understand that. But to sit there and say, calling Black members lazy, unprofessional, and snarky. Again, the court does not have to determine the truth of the statement, but the fact that they're critiquing them, whether they're Black members or non-Black members, it would be a part of making the show into what the show is. So that is very interesting. The way they worded it, I don't really like, but that's okay. We'll go with it, court. We will go with it this time. While the comments are alleged to be racist, the court cannot let plaintiff's allegation of motive control the analysis of the first prong. Makes sense. On the first prong, the court must examine the conduct of defendants without relying on whatever improper motive the plaintiff alleged. So they don't have to prove whether the statements were racist, whether they were only made to Black people, whether they were made to everyone on the team. So they kind of saved their butt on that one. These comments were purportedly made by management within the context of the retainer negotiations and the tour. Comments on job performance are in furtherance of the creative process, whether you're being lazy or not. If you just happen to be Black and they're only telling Black people they're lazy, the court says that's okay. That's protected under Anti-Slapp. The prayer circles also pass the first prong. Although the court's mind it is a closer call because you're forcing people into religion, there is more than one declaration indicating that this is industry practice or meant to settle nerves prior to performance, similar to if you decided to do like one of those little vocal things where you do the I can't do any of that cool actor stuff, but just kind of rituals before the show. So if people are saying it's common industry practice, they were able to get away with it, right? Let's see here. That bears a function relationship to the creative process as far as the prayer circles go. Quigley's Religious and sexual comments about during rehearsals are more difficult. This is where we're going to start getting into that banana. This is where we're going to get into the banana. Okay, so as noted above, plaintiff's allegation regarding Quigley's intent do not control. But even with that said, the court does not understand how the comments are connected to the creative process. Can't be. Defendant generally argues that it is part of the creative process, which is fine to the extent these are comments made during dance practice by a dance captain. But as plaintiffs point out in opposition, there has to be more. It is not enough that the comments were made during the general creative process. The actions at issue must advance the creative process. You asking about somebody's virginity is not going to help that girl dance better. Okay? You telling people that they need to believe in God is not going to help them dance better. You mean to tell me, like, girl, if you believed in God, you would dance harder. You would dance more gracefully. If you believed in God, you got to believe to dance, girl. You got to believe to dance. I don't know. I don't know what exactly she was saying, but still, I get where the court is going with this. You got to believe to dance, girl. There is nothing from the bare allegation regarding Quigley's comments about religion and sexuality that indicate they advanced or assisted the dancer's performance. Girl, you got to stay a virgin if you want to dance good. What? Notably, not a single one of the 20 declarants state that these comments contributed to the creative process. There are comments on how this was part of girl talk that plaintiffs have taken out of context. Okay, but saying it is girl talk or that plaintiffs are not telling the truth does not equate to furthering the creative process. Defendants have not met their burden as to the facet of this complaint. The same applies to Quigley's purported proselytizing during tour. Proselytize. I don't know how to say that. All of the declarations that mention Quigley studying ministry indicate that this was a personal choice and was not related to the production of the tour. Quigley's own declaration emphasizes her discussion about faith took place mostly during break. So again, not during the creative process because y'all are supposed to be on break, right? There is no functional relationship. In short, Lizzo's status as a celebrated performing artist may make some of what happened related to the tour of public interest when they would otherwise not be, but the extension is not indefinitely elastic. Remember, it has to be related to what they're actually doing. It can't just be Lizzo out to dinner, she gets to touch everybody's butt cheeks. That would not help. That would, let me not get kicked off of YouTube. Why would I say that? That does not help the creative process, right? But, you know, telling someone to tighten up while they're dancing would affect the creative process. So here we are. There is also no articulated functional relationship between the creative process and failure to address SH by the bus drivers. Gordon provides a recollection of the event, but does not connect it to furthering the creative process. It is defendant's burden to articulate how this relates to advancing or assisting the creative process, but they have not met that burden. Again, you cannot just get on the bus and the bus driver gets to touch everyone butt cheek as they get onto the bus. Why do I keep saying that? They don't get to touch your butt while you get on the bus. That does not help the creative process at all, okay? To that extent, they intend to argue that the safety of the staff is key. There is nothing linking that safety to the creative process, at least in the moving papers. Safety to, being harassed by a bus driver? No, not gonna fly. The court says no. The court also does not see the functional relationship between the Bannigan Bar and Crazy Horse and the performances. I agree with that. I am there with that all the way. The banana thing, I'm surprised they haven't mentioned that yet. I'm pretty sure it's coming. It seems like they already went through the ones that they did agree with, and we're still getting down to the things that they don't agree with. So the sexual harassment, all of that is going to stay in here at this point. Plaintiffs allege that it was voluntary in name, but not in reality for job security. Lizzo attests these events are for team building, so everyone can spend more time together in a relaxed environment. She adds that the Crazy Horse invitation was meant to inspire the dancers' creativity and improve their overall performance, so it could potentially relate to the performance. Lizzo notes that other major stars such as Beyonce have incorporated elements from the Crazy Horse show. The court is not sure how voluntary off work the court is not sure how voluntary off the clock time at a club bears a functional relationship to the performance of a set dance routine. Of course, the court understands it is a general matter and that seeing others can inspire a person to work harder or lead to new ideas. At least one declarant says these events helped the improve the show because everyone could bond, but this actively was, according to defendants, voluntary. Not all of the dancers were required to attend the club to aid in their performance of the pre-choreographed numbers. Given that, the court is not sure how something that no one had a say the court is not sure how something that no one had to say no to, according to defendants, is going to aid in the creative process. Further, Lizzo's declaration as to her intent undercuts defendants' theory. To be frank, I was enjoying a night out at Bannon Bar with friends and did not have any expectation about who would attend or how long they would stay. The functional relationship between the voluntary off the clock club activity and the concert performance is missing. Let's see. That leaves the false imprisonment and assault allegations. Those do not meet the functional relationship test. Running through a person's phone and coercing them not to leave while doing so in order to delete an audio recording bears no relationship to the performance of a concert, and defendants articulate no such relationship. The same is true as an attempted assault during a meeting. The fact that it took place during a meeting with dancers on tour does not mean there is an automatic relationship. Without more, arguing with someone or attempting to hit them does not further the creative process. You can't slap people into submission, is basically what the court is saying. Given the above analysis, defendants satisfy their burden on the first prong in part. The motion is denied, however, to the allegations regarding Quigley's religious and sexual comments, management's failure to address sexual harassment issues, attendance to the Bannon Bar and Crazy Horse, Davis' false imprisonment, and Lizzo's purported assault. This necessarily means that the motion is denied to the 8th and 9th causes of action. The court does not discuss them on the second prong analysis. The burden shifts to the remaining allegations. Likelihood of success on number 2. So I think that makes sense. What do you guys think so far? So let me pause right there because I've been reading for quite a while, and then I got quite a while going through the likelihood of succeeding on the second prong. So claims 8 and 9 were just completely denied, and that was to the assault, I believe, and the false imprisonment. And then the other things, they didn't quite meet the standard of it being public interest. While on the face of her being a public person, it should be a public interest, but it's not related to what they're actually doing. So the court is declining that it's going to be protected under that test. So let's see what the chat has to say. Welcome into everyone or everybody on the live stream on TikTok. Appreciate you for joining in. Appreciate everyone watching live on YouTube. Let's see where we're at. We're at 25 likes, y'all. We have a goal of 30 likes for this stream. So if you have not hit the like button, please do. It helps us get more friends watching live and on the replay. And we're almost at our goal. So keep it up, Beehive. Love it, love it, love it. Okay, let's see what the comments have to say. Shout out to Phoenix Fire. It's been a member for 6 months. Thank you for supporting the Beehive. We definitely appreciate it and love having you here on the live stream and on the replay whenever you miss the live stream. But I do always see you in the live stream, so we appreciate you and thank you for being a member of the channel. We have Kimmy Locker saying, I almost skipped highlighting the evidentiary issue section since it's not directly relevant to the outcome, but the court's shade was so good. It was. I agree. Tiny D says team bonding with the banana. They did not specifically mention the banana incident, but they're saying her comments during the break, which includes the banana incident, is not appropriate and is not of public concern. So you can't, you can't do that. Elin says creative expression. Yes, creative expression for sure they were going for. Just Me MD says, interesting as some of those practices they were doing on the show seem to be the reality TV antics. Remember Tyra's Top Model series always had the nude model episode every season? Yeah, so they actually found that one was not an issue as to the first part of the test. So the nude scene goes forward. That one's fine. They said it has to do with the creation of the TV show. So I agree with you there, and the court also agreed with you. Just Me MD says, now looking back, looks like they were setting up storylines for each of those dancers. Reality TV is not so reality and more scripted. Inserts eye roll here. That's true. Kimmy Lockett says to Just Me MD, yeah, new photo shoots always seem to be much about the models pushing back and occasionally breaking down. And as they did the photos to me. Yeah, I agree with that. Just Me MD, shouting or talking to Kimmy, says the model had the same reaction on Top Model. They all claim it's more about celebrating your body and boosting confidence. Yeah. But is it stressful? Yeah. I mean, I would be stressed, but I feel like a lot of people come on that show knowing that's going to be one of the episodes, right? Okay. Kimmy says they claim those are the reasons on the show, but I love to hear what they say about those episodes behind scenes. It's Cardova82 says, team building my foot. This smells of control. And the court agreed. The court said that was a voluntary thing. It's not of public interest. Like I said, going out to dinner just because you're a celebrity doesn't mean you get to do whatever you want on there. It's not in furthering the creative process. So same thing here. The court agrees with you that the team building at the Banana Bar and the Crazy Horse at least was not protected under this issue. Just Me MD says Lizzo personality on free sexuality and big girl body love is part of who she is, and it pushed more to express such. And so the court agreed with that as far as the show. What else I gotta say? They agreed with that as far as the nude photo shoot. That's what I was going to. Okay. Let's jump in. See, this is what I always do to myself. I always say, oh, it's going to be a short stream. And then I cover multiple long documents. So are we going to make it to MrBeast today? I don't know. I'm so sleepy and I have court in the morning, y'all. So that's why I was trying to make it a short stream. But nonetheless, we go on. Let's see. All right. First cause of action for the SH, a hostile work environment, sexual harassment, as if that's hiding what I just said, but SH claims require a plaintiff employee to show he or she was subjected to unwelcome sexual advances, conduct or comments, and the harassment was based on sex, and the harassment was sufficiently severe or pervasive to alter the conditions of employment and create an abusive environment. Of all the acts that form the basis of the cause of action, only the nude photo shoot is at issue on the second prong. So everything else failed to make. Oh, I thought they said the nude photo shoot did survive. Oh, it's of public interest. So it moves forward to see if it's going to be protected. On the other issue, plaintiffs point to Davis' declaration where she attests that participating in the nude photo shoot caused her to panic and made her feel terrified. So this is what you guys are saying. I thought they just approved this one all the way through, but I misread that one. So here we go. Let's see. One of the issues the court discussed at oral argument was the question of the Lao court's language concerning the viability of FEHA sexual harassment claims in same-sex environments. Okay. Accordingly, it is desperate treatment of an employee on the basis of sex, not the mere discussion of sex or use of vulgar language. That is the essence of sexual harassment claim. Let's see. In response to the court's request, the parties provided 5 cases each for the court to consider. Most of the cases presented by the parties offer clarity on the issue of same-sex sexual harassment. Such a claim is, as the case indicate, actionable. So it doesn't matter if it's both ladies or both males, you can still have a sexual harassment claim. I'm surprised that the court requested briefing on that. I feel like that's pretty obvious, especially in this day and age. Like, there's people that like the same sex and that are intending to SH you. And you want to tell me you needed a briefing on that as a court? why did you need briefing on that? Okay, let's go on. However, the Honorable Court was clear that plaintiffs still needed to present some evidence of harassment due to their sex, right? They're making you be nude, but is it because you're a lady? But no, everyone's a lady, so is it targeting you, right? There was a note of caution in the court's analysis as well. It noted that courts and juries must use common sense and an appropriate sensitivity to social context to distinguish between simple teasing or roughhousing among members of the same sex and conduct which a reasonable person in plaintiff's position would find severely hostile and abusive. You're the only one reacting to it. I think I know where I'm leaning. But let's see what the court says. Thus, these cases illustrate there are a variety of ways to establish discrimination due to sex, but it is likely clear from the summaries none of these evidentiary methods apply here. So it wasn't harassment to you. Everybody had to do it. They probably do it on every season, right? There is no indication of any sexual interest in the plaintiffs, nor any widespread sexual favoritism. So those evidentiary avenues are closed. There is no evidence indicating plaintiffs and Davis in particular have been treated differently due to their sex, or that men would have been treated differently as to the portions of the motion that made it to prong two. Not a single one of the plaintiff's declarations states as much or even supports the inference, nor is there any evidence indicating that the female defendant were motivated by a general hostility to women, because they're the women and they're promoting body positivity, right? In dealing with plaintiffs. Both cases, there must be some evidence of discrimination due to sex, and there is none here. The motion is granted as to the nude photo shoot allegations in the first cause of action. So the nude photo shoot, so I was right, but I thought they had already made the conclusion, but the nude photo shoot will basically be removed from the lawsuit. Okay, second cause of action for failure to prevent SH. There can be no claim for failure to take reasonable steps necessary to prevent sexual harassment, and an essential element of SH liability has been established. The motion is granted as to the nude photo shoot allegations and the second cause of action as well. So they basically said, okay, not only did you do SH to me, you also prevented it from happening again when I told you I was uncomfortable. The court is basically saying that cannot go forward because there was no SH to begin with. Okay, as far as religious discrimination, the only act plaintiffs needs to address in this cause of action is the prayer circles. There are three elements to a prima facie case. The employee sincerely held a religious belief. The employer was aware of that belief, and the belief conflicted with the employment requirement. Primarily, the court observes that this cause of action is more accurately described as a reverse discrimination. They're the one doing the religion. You know, it's Lizzo and her team doing the religion, not the other way around. Plaintiff alleged that they were discriminated against because they did not share Quigley's religious belief and did not join in prayer circles. So they were discriminated against because they didn't want to pray. Plaintiffs satisfy their burden. Plaintiffs satisfy their burden. They present evidence that Quigley and others were aware of the fact that some did not share their religious belief. Despite knowing this, prayer circles prior to rehearsal or performances were essentially mandatory, allegedly, even if a person did not want to take part. Plaintiff also satisfied the element that the belief conflicts with the employment requirement. Plaintiffs were allegedly required as a practical matter to attend the prayer circles, even if they did not want to, and even if they spoke up like Rodriguez. The court is aware, of course, that the defense has submitted contrary evidence on multiple declarations. But as discussed above, the court does not here weigh the evidence. So they're not proving whether the declarations were right or whether the plaintiffs were right and that they were being forced to do this, basically. In reply to I skipped some. Okay, but as discussed above, the court does not weigh the evidence. The question is not whether plaintiff's evidence is stronger than defendant's evidence or whether plaintiff has more declarations or fewer. It is whether plaintiff has some evidence that, if believed, would be sufficient. Once the threshold is met, as it is here, the court's analysis ceases. In reply, defendants argue that for the first time that all plaintiffs' FEHA claims fail because FEHA does not apply outside of California. Not a good argument, but I'm going to skip over that stuff. Finally, defendants argue that even if the conduct occurred, it was not pervasive enough to be actionable. That might or might not prove that might or might not prove to be the case. For purposes of the motion, though, the court believes the plaintiffs have put forth enough evidence to live to fight another day. Why did they write it like that? The motion is denied as to this cause of action. So far, just the nudity got dismissed. Okay, fourth cause of, I feel like, this is another religious one. I was like, I feel like we're missing some stuff on the religious things. Yeah, so this is the thing about her virginity, I think. Okay, employers are required to take all reasonable steps necessary to prevent discrimination in the workplace. Plaintiffs point out, this is also about the prayer circles. Plaintiffs point out that the supervisors led the activity and that is enough. They basically are going to find that the motion is denied as to the prayer circles because the supervisors are the one putting it forward. As far as racial discrimination, to establish the case, they're required to show that they were a member of the protected class. They were subjected to unwelcome racial harassment. The harassment was based on race. The harassment reasonably interfered with work performance by creating an intimidating, hostile, or offensive work environment, and that the defendant is liable for harassment. At issue are the comments that the dance team members were lazy, unprofessional, snarky, and generally had bad attitudes. Plaintiff Davis and Williams present enough evidence to establish that they were subjected to racial harassment. They established that they were a part of the protected class, subject to unwelcome and racist comments, and were mostly pointed at Black members of the dance team, and that the harassment interfered with their work environment. These comments came about in response to the dancers' request for a retainer, where Joshi berated them, as well as other instances of such comments by management. In reply, defendants contend that a single email is not sufficient to establish a pervasive atmosphere for discrimination, but it is not just a single email. It was not just a single email. The two plaintiffs also state there were increased tension thereafter. Davis states that BGBT management treated the Black members of the dance team wildly different than other members, for they called us lazy, unprofessional, and told us that we had bad attitudes. These remarks were made by white members in management. The implication is that it happened more than once. Whether that is true is a question of the trier of fact, so the court basically has to let this go forward. Frankly, this is not the strongest Although they have to let it go forward, the court says, frankly, this is not the strongest evidence of racial animus, impact on working environment, or prevalence the court has ever seen. But in making inferences in plaintiff's favor, it is sufficient. Defendant's evidence that other Black dancers did not experience racism only establishes a triable issue of material fact. The court cannot accord more weight to one person's experience on the motion. The motion is denied, so the racial issue will go forward. Same thing with a disability. Have to say that they suffered from a disability. They could perform essential duties of the job without reasonable accommodations and was subjected to an adverse employment action because of the disability. Davis states that she was called into a meeting on April 20 with Lizzo and Scott, at which point she disclosed her depression, anxiety, and binge eating disorder. Davis was then fired 2 weeks later. If credited, the short lapse between the disclosure of her mental health issues and Davis's termination would establish adverse employment action due to a disability. The issue, however, is intervening conduct. So you started performing bad, right? Defendants argue that Davis was fired for her recording of the meeting in violation of the NDA. Davis had admitted recording a meeting on April 27 due to a pre-existing eye disorder and general lack of feeling safe. On May 3rd, Lizzo held another meeting expressing her betrayal that someone recorded the April 27 meeting and that she was going to go around the room person by person until she found out who did it. Davis preemptively raised her hand to admit she recorded the meeting and sent it to Williams. Davis was fired on the spot. The temporal proximity between the meeting and Davis' termination was interrupted by Davis' voluntary confession to recording the meeting and sending it to Williams and the immediate termination of her employment. The court emphasizes that the recording of the session would not be enough to overcome plaintiffs' showing were that the only issue, but the fact that Davis admitted not only to recording the session, but also to sending it to Williams who had just been fired by Lizzo, and sending the recording to Williams had nothing to do with the disability, right? That was purported. That was the purported reason for the termination, and Davis offers no excellent explanation as to why the conduct would not be grounds for termination, nor is there any evidence that would suggest that if given reason is merely pretextual, which would require a jury to resolve. In short, the plaintiffs candidly and forthrightly admitted during oral argument that no reasonable jury could find causation here. The motion is granted as to the cause of action. So they dismissed the nudity, or they granted the nudity. That one is protected. And the fact that they fired her for recording the meeting is protected. It was not for disability. Okay. Seventh cause of action, intentional interference with a prospective economic advantage. This is about them not being able to work with someone else. Plaintiffs contend that placing them on a soft hold interfered with their ability to accept job offers. In order for this claim to be actionable, plaintiffs need to identify existing non-contractual relationships with which defendant interfered. By placing plaintiffs on a soft hold, the defendants point out in reply, not a single declaration identifies any existing relationship. So basically, no one sought to hire them, but they're claiming that Lizzo and her team prevented them from working. Being unable to take on a job due to a soft hold does not constitute intentional interference with a prospective economic relationship because you didn't have the prospective relationship. Further, other than this example, the soft hold did not cause any plaintiff to lose any discrete prospective economic relationship. To prevail on a cause of action, there must be specific opportunity that plaintiff lost. There is just no evidence that other than a single statement by Rodriguez, which is not sufficient. And to prevail, plaintiffs must show that the soft hold itself was inherently wrong. The motion is granted. So the fact that they couldn't get another job while under Lizzo's issue or while under Lizzo's performance is not actionable in this case. So let's see here. Let me check over here. Okay. Sorry, I'll make it a little bigger. Oh no, but then that cuts me off. Oh no, I should be fine over here. Is that big enough? Can y'all see that better? Okay. So I'm down here. I like for myself to be big, but I guess if you guys want the paper to be big, I will let it happen. No. Okay, let's get into the summary and then go from there. This case presents a number of difficult issues. Although not every allegation involves protected activities or matters of public interest, many do. And the court are rightfully wary of injecting themselves into the creative process. Speech, including entertainment or other forms of expression, are protected rights, and the law wisely disfavors chilling that conduct. Indeed, that is one of the drivers behind the legislature enactment of SMS. On the other hand, the fact that the alleged incidents take place in the entertainment and speech world is no shield of invulnerability or license to ignore laws enacted for the protection of California citizens. Finding the right balance is often not an easy task, and this case is a perfect example. It is dangerous for the court to weigh in ham-fisted into the constitutionally protected activity, but is equally dangerous to turn a blind eye to allegations of discrimination and other forms of misconduct merely because they take place in a speech-related environment. Okay, let's see here. In conclusion, in light of the foregoing, defendants' SMS is granted as to the nude photo shoot, so they can't bring that issue up, and allegations of the first and second causes of action, and is granted as to the sixth cause of action, the motion to strike. Okay, I'm sorry, y'all. I'm reading it wrong. So, their motion to strike is granted for the nude photo shoot. The other things, the disability, and the seventh cause of action to the intentional interference with prospective economic relationships is denied to all the remainder. So the religious discrimination, the sexual harassment, and what was the other one? I forgot what the other one was. I feel like there was one more thing. But yeah. So what do y'all think about that? I think that the court did a pretty good job with it. there were some things, like I said before, it was not supposed to be a blanket protection, right? But there were some things that were still protected. So she got away, or not got away with it, but she was protected as to the nude photo shoot. They can't bring that issue up. And she was protected as to, I didn't scroll all the way away. Nude photo shoot, the disability thing cannot go forward. And I forgot what the first and second causes of action were. Oh, in the first and second. So that's just a nude photo shoot, but the other sexual harassment claims are going forward. And granted, as to the sixth and seventh cause of action for the discrimination and then the intentional interference. So everything else stands. The sexual harassment is the main thing, in the religious discrimination. Those are the main things. I can't remember what the last thing was. So let me go ahead and check out the comments and see what the chat had to say. But before we do that, I got to drink some water because your girl is thirsty. Okay. Let's see where we are. So I forgot. Bossy, bring us in. All right. So Spirit of the Tree says, seem like the prosecution is laying it out quite chronologically. And so this is not the prosecution. This is actually the court that wrote this. And it's plaintiffs. This is not a criminal case. So it's just civil. It's a civil lawsuit, though. So there's no prosecution, but the court did definitely lay it out chronologically and made it very easy to follow. I confused myself partway through the through what do you call it? What they were deciding. I confused myself a little bit about it, but now I get it. So the nudity was dismissed. The discrimination for, what do you call it? The religious discrimination, or no, it wasn't. The disability was dismissed, and then the interference with their contract was dismissed. But everything else is upheld. Kimmy Locker says, let's see, this is the judge's analysis and ruling in response to Lizzo's motion to strike. She's being sued civilly, and there's a plaintiff rather than prosecutors. Yes, exactly. Just Me MD says, isn't prayer or good vibe circles common in the industry before a performance? We see this a lot, like it's a pre-performance ritual. This happens in sports, theaters, and other performances. And that is a yes. The court did mention that it seems like it's an industry standard. However, the plaintiffs are basically going to have to go through it and prove their case. So the court is not weighing in on the facts of these kind of things, but they're basically saying that the defendants, Lizzo, knew that they did not practice this religion, but they were not able to opt out of it. And then Lizzo will be able to bring in other people to testify that, no, we were allowed to opt out of it. And then the court can decide whether they were discriminated against it. Because if there were people that opted out of it, but they were like forcing the plaintiffs to stand in the circle and do the prayer, then that would be, grounds to find that they were discriminated against. So the court is basically not analyzing the facts of everything, but leaving that to the jury to determine whether it will be considered discrimination. Small says, to Just Me MD, very common. I don't know an artist, cast, band that doesn't do it. Doesn't have to be religious, and those are usually just do it for bonding purposes. And remember, y'all, we talked about this before in this case. It kind of seems like it's retaliatory. They got fired, and then now all of a sudden they're bringing up all this old stuff suing Lizzo. Like, while they may be in their right to sue her for these things, do you really think it was a big problem during it? Do you really think they were like, oh, I don't like this, prayer circle, I'm not going to do it? Or did they just do it for the team bonding purposes? Remember, they filed this after they were fired. So good point to Smalls. Kimmy says, let's see. The court said the prayer circle is protected under prong 1 for bearing a functional relationship to the creative process, but denied dismissing it under prong 2 since it, allegedly required and conflicts with an employment requirement. Right. So they're going to have to come forward and present the evidence that no, it was not conflicting. Remember, the court cannot determine what fact is true or not. They have to say, if true, could the defendants prove their case? And that's what happened here. If true, if they were forced to do the prayer circles, then the plaintiffs could, I'm sorry, I said defendants earlier, but then the plaintiffs could win their case. So they're not balancing the facts at this time. Just Me MD says this case may set a precedent for future performance activities. Yes. And it's really going to depend on if they were really forced to be there, you know, or if they could have sat it out, right? Like in school when they try to make you do the Pledge of Allegiance, they couldn't force you to do it. Let's see here, where are we at? Small says that's just my thought / concern. That's just my thought / concern, and I'm gonna be pissed if it does. I'm not Christian. I sit quietly in prayer circles all the time. That's such an holish non-issue, claiming a thing to include. Exactly, like I said, they filed it after they were fired, so they're probably just being dicks about it at this point. That's what I would assume too. Small says, I meant to say those who aren't, as in non-religious, non-Christian members, are still willing to do it and or want to do it. It's a long-standing pre-show ritual to get you centered, ready for stage. That's it. Small says, I meant to, oh, I already got that one. My bad. The Young Legend says, so many people have a desire to be part of the industry, not realizing that they're made to lay aside their morals and integrity. Like the Matrix, you either take the red pill or the blue pill. That is true. They may have put it aside while they were on the team, but now that they're not on the team anymore, they have a problem with it. I think I just, this one. Okay. Cardoba82 says, it is if people feel compelled to do it because the person in charge is the one demanding it. Right. And that's one of the points that the court pointed out, is that the supervisors are the one leading the prayer circles. So that's where it becomes an issue versus like if it was just people on the side doing it, right? Okay, Small says, like I said, we can all be respectful of other people's religion. Sitting quietly or even tuning folks out costs nothing and doesn't harm anyone. They're not hexing folks with a curse. They're claiming that they called them out when they did not go into the circle. So it'll be interesting evidence to see go forward. Small says, agree to disagree. If they're being made to pray, sure, be present. Nah. It wouldn't be a big deal to me. I'm not Christian. I'm not religious. And it happened to me all the time. And cheer and dance and step show and anything. It's just what people do. It doesn't bother me, but a lot of things don't bother me. So I don't know if I'm the, standard that we want to base things on. Tiny D says we hit our 30 likes. Did we? Thank you for pointing that out. Yes, we did. We did. We are at 34 likes. We are at 34 likes. Thank you for everyone that hit the like button supporting the stream. We hit our stream goal. I got to come up with some new sounds on my soundboard. I know I always say this, but I actually need to do it. Thank you, Tanya, for pointing that out. Casta Sass says, we did it in theater in high school, but it was just a circle where we hyped ourselves up. Yeah, and it could really be anything, right? It could really be anything. Let's see. Small says, I probably would have called him out too. Get in the circle with the team member, team bonding, right? The banana in bar, the crazy horse, all the things you want to be a part of the team. Is it going to hurt you? Probably not. And so right now, y'all, I'm going to go ahead and shut off TikTok because we ain't got nobody in there. Shout out to everyone that stopped by in TikTok, but we're going to turn them off now. All right. We got some views. We got some diamonds. Oh, we got 2 diamonds. I don't know what that means, but we got 2 diamonds on TikTok and we got 1 new follower. So shout out to the people that popped in on TikTok. Okay. Okay. Thank you very much, Kimmy. What I'll probably do is cover MrBeast at the beginning on Thursday if I don't get through everything on it. So yes, I got your comment in the back. Just Me MD says, Lizzo made it very clear the show was to get additional dancers for a certain tour and that only a few would continue on as permanent dancer. They knew going into it, it was temporary. Yeah. I mean, one thing I learned in life is people are going to find something to complain about. They're going to find something to complain about. Even if they knew it, they're going to make you the problem. And since Lizzo has deep pockets, they're going to make her the problem, right? So let's bring it in, Buzz. Oops, I thought I hit Bossy. Let's bring it in. Let's go ahead and hop over to Mr. Beast and his anti-slap motion. Like I said, I forgot that we actually covered Lizzo's basically an anti-slap motion, the motion to strike certain parts based on anti-slap. Now we're gonna jump into Mr. Beast anti-slap. We may have to cover the rest of this on Thursday, because I ranked today. And I don't have the time to go over it, y'all. I have court in the morning, so I can't be here super late tonight. But shout out to all of y'all for hanging in there with me and going through Lizzo. I feel like the Lizzo document was very informative. Let me know in the chat if y'all also think it was informative. And then, like I said, Mr. Beast is pretty long with everything that is in his motion. So what I'm going to do, since it is so long, let me see. Did you highlight this one, Kimmy? It doesn't look like it. So what we probably will do is go through the notice, and then we'll do Mr. Beast. We will not do Mr. Beast. We will cover Mr. Beast on Thursday, and I'll redo the thumbnail so that it'll be ready for Thursday, so we can get some people liking it and coming into it. So let's go ahead. Okay, sorry y'all. And I was actually looking at the Kimmy. I see that you sent it in the back. Thank you for that. I was looking at the longer ones, if those were highlighted. So not this one. So yeah, we can go over this, and then we'll go over the more meat and potatoes of this on Thursday. So sorry, y'all. I thought I had the time. But you know, Kimmy is so good. She always gives me like 6 documents, and I'm like, I thought it was like 1 document, and I thought it was like 3 pages. But you know, that's what happens when you live react to things. And you watch it for first 48 before your live stream and get pulled in. Okay, let's go ahead and jump into Mr. Beast. I know Bossy came by, but she wanted to come by again. So let's see what is going on in Mr. Beast. Y'all like to see the documents, so I'll put my little self in the corner by my lonesome. All right, the notice of motion for the oral argument is requested. Please take notice that upon the memorandum of law, the affidavit of James Donaldson, and the exhibits annexed thereto, plaintiff and counter defendant Beast Investments and James Donaldson will move this court in the motion submission part located in this particular room for an order dismissing the counterclaims filed by counterclaimants Celebrity Virtual Dining Concepts, and Virtual Dining Operations, and each cause of action therein pursuant to the New York civil rights law, also known as New York's anti-slap statute. Remember, the people that contracted with Mr. Beast is suing him, claiming that he said bad things about them on the internet. Kind of like Lizzo's case of they're being mean to me, so now I'm going to sue you. And Lizzo saying, this is part of my show. I get to be mean to you during rehearsals to a certain extent, according to the court, right? So he's basically alleging that he's like, I was free to say these things because they screwed me over in my contract, is basically what Mr. Beast is saying. Okay, let's see here. Cut off my face when I do that, but that's okay. Let's see. Okay, the motion is made on the following grounds: the allegation and requested relief and counterclaimants constitute so many counterclaimants. Okay, the counterclaims constitute an attempt to suppress and chill Beast Investments, and Donaldson's conduct in furtherance of their constitutional right of petition and or free speech, And counterclaimants cannot meet their burden of establishing by clear and convincing evidence that any of their allegations specifically addressed in the motion have a substantial basis in law or are supported by a substantial argument for an extensive modification or reversal of the existing law. Beast Investments and Donaldson can satisfy the first prong of the anti-SLAPP statute because each of counterclaimant's 6 asserted causes of action arise from statements made in a public forum in connection with a public issue or an issue of public interest. You are feeding us bad burgers and you're putting my name on it. And I am a famous YouTuber man slash pseudo. I mean, I guess he's not a pseudo celebrity at this point. I'm a celebrity, says MrBeast. So this concerns public interest. I think he's going to win. Based on, I know this is under New York law. but I think he's going to win based on what we just read in Lizzo, right? Let me know what y'all think so far in the comments about this. Is MrBeast going to win this? I think he is. Please don't prove me wrong, MrBeast. Okay. Let's see where we're at. Indeed, it is black letter law that statements published on social media platforms such as X, formerly known as Twitter, are open to the public, and that public social media websites, including X, are public forums for purpose of the anti-SLAPP law. Furthermore, the social media posts at issue clearly concern a matter of public interest in that they concerned, among other things, the quality of products and services at MrBeast Burgers, which topics were the subjects of ongoing widespread public discourse. And MrBeast is low-key a celebrity for the purposes of buying Beast Burgers, at least, because people buying Beast Burgers are probably buying Beast Burgers because they know MrBeast, not just because they want a Beastie Burger, okay? Regarding the second prong of anti-SLAPP statute, counterclaimants cannot show that any of their claims for breach of tortious interference or a permanent injunction have a substantial basis in the law. For the reasons set forth above and in the motion, the court should grant the motion and dismiss the counterclaims in their entirety, or in the alternative, all the allegations of protected activity and any other relief the court deems proper. Yeah, we would not have time to go through this today. Should counter defendants be deemed the prevailing party on this motion, they will seek an award for reasonable attorney's fees and costs incurred. Pay me if I win, is what he's saying. The motion is made and based upon the notice of motion and motion, the accompanying memorandum of points and authorities, and the declaration of James Donaldson, and all exhibits and attachments thereto, the pleading and documents on file in this action, any matters upon which the court may take judicial notice, and upon any furtherance or any further oral or written argument of the evidence. Okay, so this is basically just giving them notice that they intend to file the motion, which they do, and which I do have the documents to, but we are going to have to cover it on Thursday. Hopefully, maybe we'll have two videos ranking for MrBeast coming up here. Yeah, this is gonna be, although it's not as long as Lizzo's, it's going to be too long for me to cover right now, but that's okay. We still have Thursday. We'll cover it then, and that probably will be the only case that we cover. I got to start considering how long each of the motions are, thinking I could just get through them quickly. Shout out to Kimmy for highlighting the documents for us. She finds the important parts. Y'all know if I were to do it, I would read the whole goddamn thing because I think that everything is important. But shout out to Kimmy for pulling out the important parts of the lawsuit. So let's see. Kimmy Locker says, I haven't gone through MrBeast's entire anti-SLAPP motion, but based on the notice and what we read in Lizzo's case, I definitely think he's got a good chance of winning. I do too. If he's saying these burgers suck and my name is on them, don't order my burger. Is it a breach of his contract? Maybe, because he's supposed to be promoting the burgers. But at the same time, is it a public interest? They're saying the food's not cooked all the way. It's not properly put together. I think he should be allowed to say something about it. So I agree with you, Kimmy. I definitely agree with you there. Let's see. Spirit of the Tree says, gotta head out, but love the vibe tribe. Love it. Until next time, heart to breathe. Well, thank you for joining into the live stream. Glad you enjoyed it. Your girl's about to tap out as well because I'm tired. And we're going to jump into MrBeast, the rest of it, because I don't have 2 more hours to go on the live stream today. Like I said, I do have court in the morning. So I have to be up pretty early to try to win and kick these people's butts. So wish me luck. Thank you everyone that joined into the live stream. Let me see where we are and the likes. 35 likes with 25 people watching live. Shout out to the Bree Hive. If you have not hit the like button, please do. It helps us get more friends watching live and on the replay. And if you're watching on the replay and you haven't hit the like button, please do. You made it this far in the live stream and we're pretty deep in here. Like I said, we are going to cover the MrBeast case, or not the case, the update in MrBeast regarding him filing the anti-slapp and his reasoning as to why anti-slapp applies here, and that the virtual dining should not be able to basically countersue him for him suing them to get out of the contract because they suck. Right? Because they allegedly suck, according to MrBeast. So let me correct my sentences. We are on YouTube and we do have people coming after people online. So I will watch my words from now on. But either way it goes, thank you guys for joining the Tuesday live stream. I hope everyone has a wonderful night. And I will see you all on Thursday to